You know what? I do have a problem. I'm looking at it after I'm telling you all that. Maybe I can just speak with her, or unless you want to assist me. His name is Charles Claver. K-L-A-V as a Victor E-R. I did. Okay, I appreciate it. Thank you. What's going on, Gary?
I was going to say before the media service, when we call hers, I don't know. Order, she's here. I had a dental appointment.
Gary, she wants to get this out the way.
I know, this is just all I'm doing is setting aside the thing.
I'm trying to tell you, that's her. She wants to do it. You can approach with the prosecutor if you like.
Yeah, we'll just approach real quick.
Nope, I have somebody to want to approach before you, though.
I was here before him.
No, he approached me to approach before you just approached me.
But he doesn't mind if I go first.
Yeah, that's between the two of you.
You don't mind, do you? Good, I got a broken tooth.
I got officers in here waiting as well.
I'm like in pain. I'm drowsy.
Look, I have officers here as well on this case.
But it's going to be a long time, Tina. I'm in pain. Remember yesterday I broke my tooth?
No, I didn't talk to you yesterday.
She did, because I came in here.
I don't remember you coming in here saying your tooth was bothering you.
Yeah,
I wasn't listening. Dr. Gilbert, this is Tina calling you from Judge Shannon Walker's courtroom regarding the report on Charles Claver. The CFP number is 82653. You can give me a call back at the earliest convenience. The number here is 313-224-5237. Thank you. Okay, so hopefully the doctor will call me. But you know what? I'm calling to see if she got a report.
Also, cut,
And if not, we're just going to put it out another month. You know what I'm saying? But if I don't hear from her by the end of the day, that's just what we're going to do.
get them out.
Can we get, I want to hold Beetle and Simon out to move their Did you come up with another date?
No, whatever's good for the court. Mr. Beetle? Any dates you have?
What's the reason?
He's going to be doing the 3-year sentence on Monday, and he's sentencing after the Fed, so it'll be concurrent.
Okay. He's going to be sentenced on Monday?
Yeah, they're sentencing Monday, yeah. So anytime after that.
You don't need that intention?
No, you got Susie.
You got somebody already?
Susie, too, yeah, thank you.
Okay, well, let me cancel what I call.
Thank you.
How about?
Are we getting out of the way now? We'll get out of the way.
No, y'all setting a date. Y'all
just
setting
let
a
me-
date.
just let me know
Give
when.
me a date.
Friday the 15th?
Yeah, I can make that work.
You have people here in behalf of him?
Good.
You have people here in behalf of him?
Anybody here for Evans?
Okay.
Did you see the guidelines on this one?
Yeah.
You got a heck of a deal.
Tell
No,
me
they're
something.
off by one.
Okay. We're all set?
Should I hold on to this, or?
You want to, or you want me to hold on to it?
You better hold it, I might lose it.
I got you. All right, you ready to call my case?
Thank you. I'll see you. Thank you, Judge.
All right. Faqua, step up, please. How can I help you? Oh, you know what? Sorry, I didn't call you, but we ran that gentleman down here, but they down in Kenny now, so I'll call you right back. All right, thanks. This is case number 156214, People versus Dezman Faqua.
Appearances?
Hi, Your Honor. Good morning. Michael Woodard here on behalf of...
Good morning, Your Honor. May it please this honorable court. Antonio D. Tuttles on behalf of my client, that's Mr. Faqua, who stands now to my immediate left arm.
Good morning. Good morning, Mr. Faqua.
Good morning.
Your Honor, today is the date and time set for a sentence in this matter. I've had an opportunity to review the pre-sentence investigation report with my client. It appears in his body to be factually accurate. However, we do have some issues with the guidelines.
Whenever you're ready, we'll go with that.
Okay, I am ready. People.
Judge, yes, I don't have any corrections or additions to the body of the report itself, but I'm prepared to discuss that.
Let's start with the PRV.
I'm fine with the PRVs. I understand that the people that scored PRV 5, I do not believe PRV 5 should have been scored. Actually, the people did not sentence in PSI interview it did.
Your Honor, I believe that prior record variables 1 should be 0. 2 is scored at 10. I believe it should be 5.
Any objection to PRV being scored at 5, Mr. Clerk?
No, Your Honor.
I believe PRV 4 should be scored at 2 points. PRV 5 should be scored at 5. PRV 7 should be scored at 20 points for the concurrent convictions, which would be a total of 32 points.
And PRV 5 deals with prior misdemeanor convictions or prior misdemeanor juvenile adjudications. I believe Mr. Faqua has 3 misdemeanor juvenile adjudications. So PRV 5 will remain at 5. And I believe that makes the total 32, and it remains at level D.
Yes.
Any
changes to the offense variables?
The offense variables, specifically, Your Honor, as it relates to the offense variable 3, I believe was scored at 25. And I do not agree with that. Because it's my understanding, as it relates to the injury to the victim, it is clear from the testimony that, in my opinion, that my client was not a shooter in this particular incident. So he personally did not cause any injuries to anyone.
I believe there was a theory of aiding and abetting. Mr. Woodyard?
Your Honor, the case was presented as a theory of aiding and abetting or principle. And I think that clearly under that theory, Mr. Faqua is liable for the death of the victim, predominantly of the crime of second-degree murder. Judging so under that circumstance, it's our position that 25 points is appropriate for offense variable 3, where life-threatening or permanently incapacitating injury has occurred.
And the court agrees with the people, so OV3 will remain 25.
Your Honor, the offense variable 5 was scored at 0. I believe it should be scored at 15. That would require that serious psychological injury requiring professional treatment has occurred to a victim's family member. As the court recalls, not only was the victim deceased in this matter affecting his broader family, but his son was the direct victim of the case itself. He sustained injuries. I think that under OB5, 15 points.
And both of the deceased children witnessed the murder of their father, so definitely OB5 should be scored at 15.
I disagree, but I do understand.
Judge, offense variable 8 is scored at 15, and I believe that's appropriate. OB9 is scored at 10, I believe that's appropriate. OB10 is scored at 15, but I think that should be 0.
Any objections to cover?
No, Your Honor, I agree. OB10 should be 0, not 10.
Let's go OB10 at 0. What about OB6 that was scored at 50 points?
Thank you, Judge.
I believe that should have been 25, Your Honor, as opposed to 50.
I believe it should be 25 points.
And OB6 will be scored at 25.
Judge, the only other offense variable that was scored was OB14, and it was scored at 10 points. The only time that the court would score that is if it finds that the offender was a leader in a multiple offender situation. In this matter, I know, although the court concluded that Mr. Potpourri was indeed involved and responsible, it did not find that he was a leader. In fact, I don't think there was any evidence presented to that effect. I would think it should be scored at 6.
Any objections?
No, Your Honor, I totally agree. OB14 should be 0.
The Do the parties agree that the total OZ is now 120 and it remains in level 3?
I do agree, Judge.
Yes, Your Honor.
And the guideline range is 270 months to 562 months?
Yes, Your Honor.
Yes, Your Honor.
And that
Because of the half second.
That takes into account the habitual offender sentence.
Yes.
Mr. Wood, you have anything on behalf of the people?
Your Honor, we do have statements from victims that the court would permit.
The court will permit such statements on behalf that they address their statements to the court.
And I've spoken with the family and advised them of the procedure. Shall they stand there?
Yes, please. Good morning, sir.
Good morning.
Could you state your name for the record?
Christopher. Reed.
All right, Christopher, whenever you're ready.
Why did you choose to do this? He shot me, gave my brother nightmares, and he took someone that was in the center of my heart. You know, well, he wouldn't want nobody to take his baby life. Another bag out of the street. Just think about it. Just think about what he did. He is going to cry his eyes out. And he actually did it. That was a bad idea. Now I have to live with it for the rest of my life.
Thank you, Christopher. Good morning, ma'am.
Good morning.
If you can state your name for the record.
Reali-Tea.
Whenever you're ready, Ms. Reed.
June 6th was the worst night of our life. He took someone dear, special, and loving from us. I thank God and the judge, but not only the verdict of guilty, but saving another family from devastation. There is one demon off the street. On June 6th, our lives were devastated and incomplete, all for one selfish act. What was taken from us can never be replaced the same. A loving father, son, brother, a best friend, someone special to all who knew him. Someone well loved and needed. No amount of time served will ever take away the pain or the countless tears. Mere words can never explain. Because of the actions committed, Christopher will never be at his kids' birthdays, school plays, graduations, weddings, etc. So many plans and dreams were destroyed in just that one night, something that could never be forgiven. Christopher's children will live with this for the rest of their lives, which is exactly what we recommend and be deserved for this crime, life.
Thank you, ma'am. Anything else you have to people?
Your Honor, Mr. Faqua's record demonstrates again and again and again that he has no regard for the community in which he lives, for the safety of others, or frankly, it appears for his own well-being. Our concern at this point, of course, is the larger community. Judge, I think that the court should sentence Mr. Faqua at the top of the guideline range to ensure the safety of the community.
Could you tell us anything else you have for your client?
Your Honor, I understand the devastation that the family may have gone through. However, my client has continued to maintain his innocence throughout. And I believe at best, Your Honor should sentence my client at the low end, hopefully the bottom of the guidelines, understanding that whatever that is plus 2 years.
Mr. Faqua, this is the day and time scheduled for sentencing. Is there anything you would like to say on your own behalf before I impose sentence?
Feel remorseful for whatever happened to their family. I hope they can get past the situation and find the right person who did it.
Well, I have to agree with Ms. Reed. It doesn't matter how much time they're sentenced to, is not going to bring the late Mr. Reed back, but hopefully in time the family will find peace. So on count 1, murder in second degree, your sentence is served 25 to 50 years in the Michigan Department of Corrections. For one count of assault with intent to do great bodily harm, less than murder, you're sentenced to serve 3 to 15 years. For one count of carjacking, you're sentenced to serve 15 to 30 years. On one count of armed robbery, you're sentenced to serve 15 to 30 years. On weapons, firearms, possession by a felon, you're sentenced to serve 3 to 7.5 years. Those counts will run concurrent. On the felony firearm count, you're sentenced to a mandatory 2 years, which is consecutive to counts 1 through 5. And you'll receive 209 days credit for time served. You must pay a $60 DNA fee. State costs in the amount of $408, a crime victim's assessment in the amount of $130, and court costs in the amount of $1,300. You have the right to file a claim of appeal to your conviction and sentence. If you choose to do so, you must do so within 42 days. If you cannot afford an attorney, the court will appoint an attorney, furnish the attorney with portions of the transcript and record necessary to handle your appeal, and this request must also be done within 42 days.
We acknowledge receiving. He is executing the same, Your Honor.
In the back.
Yeah, she said that. You know, I wouldn't my pass.
The council's approach on Mansfield?
Yes, sir.
All right, Jim. Yeah, from yesterday.
Thank you.
Take care, Christopher. Take care.
Ms. Hines, you're approaching the council on the case, please. Thank you.
Did they find you this morning?
Yeah, he said.